Under English law, there is a flat prohibition on assisted dying. I will argue that medical assisted dying for the terminally ill should be legal. My argument is in three parts. First, I will identify two principles which justify legalisation. Secondly, I will challenge arguments opposing legalisation. Thirdly, I will highlight failures in a flat prohibition and outline what is needed for a law on assisted dying. I will now address the first of these three arguments. I rely on two justifying principles advancing the case for legalisation of assisted dying. The first, autonomy, refers to a person's own free conscience to control both his life and, to some extent, the time and manner of his death. The second justifying principle, beneficence, is an act of another, in this case a doctor, that is beneficial to the recipient. In the case of terminally ill patients, the act is beneficial to the recipient if death is permitted painlessly as a relief from suffering. The case for medical assisted dying for the terminally ill in itself cannot be criticised unless one challenges the inviolability principles. I reject theories that imply that choosing death is not autonomy or that human suffering is inevitable. This leads on to the second of my three arguments. I will not challenge opposition which relies on cultural or religious conviction. In the first round of this competition, I submitted that the administration of the law should be uniform. Law cannot, therefore, be determined by one community's cultural or theological doctrine. My arguments are driven by reason. The only arguments raised by opponents which do not depend on cultural or religious conviction are slippery slope arguments. I will therefore only challenge such arguments. The logic is that if you allow A, although in itself it is a good thing, you will eventually have to allow B, which is abhorrent. Empirical rather than conceptual slippery slope arguments make assertions about legal control and moral change. These both commonly follow the legalisation of some previously prohibited activity. The legal control argument maintains that you cannot prevent situation B if you allow situation A. The only workable line is a complete prohibition. The assertion is that the law will not be able to prevent the non-voluntary medical killing of the vulnerable. There is evidence to the contrary. One can identify in countries where there is a flat prohibition behaviour associated with secrecy, a lack of control, opaque decision-making, and the exclusion of representatives. Data from Oregon shows that those in vulnerable groups, except perhaps patients with HIV, are not overrepresented amongst those assisted in dying. Legalisation leads to a reduced, not increased risk for those who are vulnerable. The moral change argument maintains that once we allow A, we will sooner or later allow B. The moral change argument asserts that moral standards will decline and the abhorrent will occur more frequently and eventually be legalised. This argument evidences nothing but distrust for future administration of law. We are in effect claiming that we possess a better moral insight and future generations will fail to make morally important decisions. We can't legalise A, because if we do, they might legalise B. Trying to bind future moral judgment is an ethically improper basis for public policy. What type of society would we live in now if our moral choices had all been made for us in the 19th century? This leads on to my third and final point. Judges, with an outdated legal regime, find escape routes to acquit doctors who assist the terminally ill in dying. This is reducing legal certainty. The doctor is immune from the Woolen direction, and thus acquitted where she did not intend the death of a patient, although, in administering the drug, death was a virtually certain consequence. Another covert tool used is jury nullification. Prosecutors, as a result, have been more willing to accept guilty pleas to lesser offences, thus avoiding jury trial, and have made selective charging decisions so as to avoid the risk of jury nullification. This has made convictions more unlikely. In a study of terminally ill patients in Oregon, about half the patients interested in assisted dying changed their minds. Lord Falconer's Commission on the Assisted Dying has proposed, amongst other safeguards, that any decision made by a doctor concerning an individual's eligibility to die would have to be seconded by another doctor. The patient would then have to wait for a further 2 weeks before being assisted in dying. The terminally ill should be offered medical assistance to end their lives. Empirical slippery slope arguments are unfounded. Legalisation would reduce the risk for the vulnerable. Trying to bind future moral judgment is morally pretentious. Appropriate safeguards would thus require a reflective decision made over a period of time with professional consensus of the parties' settled intention to die.